Hi, I'm JP Sarmiento from the Sarmiento Immigration Law Firm. Today I'm going to talk about what Secretary Janet Napolitano put to passing back on January 2013, which is the Provisional Waiver effective on March 4, 2013. Now, this waiver is a big deal for a lot of people who've been here unlawfully present, those who came illegally, for example, who are married to a U.S. citizen, and who have some hardships to their U.S. citizen if they are to be separated. Prior to this law, when these people would consult, for example, you ask the common questions. Were you persecuted? Maybe you're eligible for asylum. Is there a one-year rule exception? Have you been here over 10 years? Do you want to apply for cancellation of removal? Which is a higher hardship standard to overcome in this situation. Or sometimes when they ask you that question, you say, there's nothing we can do other than wait for the new law or risk having to go back home to your home country, apply for the waiver there eventually. And if that gets denied, then you won't get to come back to the United States for 3 or most of the time, 10 years. But with this new law, in a situation where you are inadmissible due to being unlawfully present in the United States, and let's say have immediate relatives, let's say you're married to a U.S. citizen, have U.S. citizen kids, for example. If you have a little bit of hardship that you think can overcome the extreme hardship requirement for waivers, then it's worth a shot to do it over here. Now, what's the difference between this new law and that other law? Well, it's the stress of knowing that you have to win the waiver abroad before that person can come back here to the United States. So let's say you're a U.S. citizen. Your spouse is an illegal immigrant, unlawfully present in the United States for, say, a couple of years, 5 years, okay? Before you file a petition for your spouse, that gets approved. Spouse has to go to his home country, apply for the immigrant visa waiver there, immigrant visa there, gets found inadmissible due to being unlawfully present, has to apply for a waiver. What's the stress in there? What's the risk in there? Waiver gets denied, he or she won't be able to come back for 10 years. Sometimes 3, but most of the time 10. Most people become unlawfully present for over 6 months anyway. But with this new law, you can apply for both, the I-130 here, the 601A. I think that's the form. It hasn't been, finalized yet for the provisional waiver. And if that gets approved, when your spouse goes home to his or her home country to get the immigrant visa, there's no risk of getting a waiver denied anymore. No need to wait for that for a few months because that was approved already. And so it just goes there to get the immigrant visa. It's almost a guarantee, although you cannot say that. There might be some criminal records or other forms of inadmissibility, but if in that situation, it bodes well for a lot of people who were hesitant, who have some hardships that they think they can show, but they're just scared that the U.S. Embassy abroad would still deny it. And so, if you have kids here or you're married here, you have established business, good work, residence here, you don't risk missing all of that because you're trying to see whether your waiver would get approved abroad. So that's a big deal. One last note though, and this would be a separate topic, and there's a lot of articles and a lot of publications the past 2 days on this provisional waiver, and just be careful not because you're eligible to file for the waiver, or not because you qualify to apply for it, meaning you have immediate relative inadmissible solely because of being unlawfully present. I mean, it's not a guarantee that's going to be approved. And it's kind of funny because I rarely see this, but it's still a waiver application, So it's very important to check on that as you do it, or as you retain a counsel, probably. It's still a tough burden to meet. You still have to show extreme hardship, which is a separate topic in itself. But just on top of my head, you have to show, like, for example, some medical hardships, if there are. Those are good. Financial, emotional, psychological hardships, how long you've been here in the United States, that bodes well, family ties in the United States, probably lack of family ties abroad, country conditions abroad, financial, economical situation abroad. They combine all these factors so that you can meet the extreme hardship requirement. And only then, with the waiver, whether it's provisional waiver or the typical 601 extreme hardship waiver, only then would you win that and eventually get either an immigrant visa if it's a consular processing case, or a green card. So, but it's great news. I don't know what the exact statistics are, but just based on my readings over the past 2 days, I think 1 million or so people would be helped, which is understandable, and I'm not surprised about that. Every day, lawyers, I myself, hear about this. Oh, attorney, what can I do? My husband, my wife came here to the United States illegally 6, 7, 8 years ago. We have 2 kids now. What can we do? At that time, 2 choices: do nothing or risk going abroad, apply for a waiver there after the petition. Now this is another option, and it's better because family is here. If it gets approved, the trip abroad would probably just be a week or 2. Well, that's what they say, but it should be that way because it's just the immigrant visa at this point, just to pick it up for the interview. So that's great. If you have any questions, feel free to call our firm, 216-573-3712. Again, that is 216-573-3712, Sarmiento Immigration Law Firm, or visit our website at www.sarmientoimmigration.com. It's going to be on this video, going to be superimposed. So, this is great news. Thank you.